Week 9 is on skill and care, and it's a good topic to do comparatively, and we'll look at the UK and also German law. So, what are the tensions? What's the battleground, if you like? So there's a significant delegation of power, meaning that directors have a broad remit to manage the company. And that has to be because the activity is one that just requires decision making as life goes on. Then, of course, having lots of power means there is potential for that power to be abused. And in addition, the job involves taking risk. So this is not like the role of a surgeon where you have protocols that tell the surgeon exactly how she needs to perform certain steps. Being in business isn't like that. Entrepreneurial risk taking is much less defined. Then, so that's sort of that's what you're dealing with. How do you set a standard against that background? Then the problems are something called hindsight bias. The review of a decision in the past is affected by our knowledge of what happened since. So if you think about the current issue with coronavirus, if you go back to what people said publicly and thought publicly in January, you'll find that their assessment of the situation was very naive. And that appears to us now, you can easily jump to the conclusion that they were at fault in not taking this more seriously, but you only do that because you know what happened since. So that's hindsight bias. Another question creating attention is, are the courts qualified? Because judges, of course, aren't entrepreneurs. In the UK, they may have been practicing lawyers who also run a business, but that's not the case everywhere. And in particular, the business of being a lawyer is very different from running other businesses. And then, how far can you get by consulting expert witnesses? So these are the tensions. So this is sort of background knowledge. What's the position in the UK? The common law was codified in the Companies Act. There's insolvency law as well, and disqualification law. And the fact that we have disqualification law shows that there is a significant public interest element in this. Otherwise, government would not involve itself. Now, how did the common law develop? The common law is developed in the context of trustees. So that had to do with historically companies being organized through trust law. And of course, the rules for trustees are suit that environment, and then were sort of moved into company law where they were developed. They've been now codified, but we continue to have regard to the common law and to equitable principles. Here are so the duty now of skill and care is set out in 174, and here are examples of cases of how that duty developed. Now, the original idea was that the standard of skill and care is the personal standard of the director concerned. And this makes perfect sense, because if you assume shareholders choose the directors, they have every incentive to be careful in doing that. And if they haven't been careful, that's their problem. So if they find someone as a director who is very lazy or unqualified, then they can remove him, but they're stuck with what they chose. That, of course, applies for, you can say, private companies, but even there, the idea has become, we've moved away from that. And certainly for listed companies, shareholders realistically are involved in identifying directors, but they're not very engaged in doing that. So there is a sort of public interest element. So the new duty, therefore, is an objective one, which, so 174, the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the same function as the director. So you work out what can reasonably be expected of someone in that role, plus any additional general knowledge, skill, and experience that the director actually has, and to work out what the general knowledge, skill, and care of a director is, you look at the business of the company, size of the company, what role it is, and what type of executive or non-executive director. So we've got a shift from a subjective standard to a standard with an objective component, and the standard can be even higher if the director concerned has additional skills. Now, here we move on to a sub-question, which is the question of delegation. And the question is, how much supervision do the directors, the members of the board, have to undertake? And the original one was assume all's well and act on suspicion. Now we believe that's not enough. You need to keep yourself informed. So that's not quite assuming that something's gone wrong everywhere, but being critical, asking critical questions, and ensuring that you keep yourself informed about what the company is doing. So the way, a good way to describe it is the board needs to guide, be a critical friend, but also monitor. And it's at that point that internal control systems come in. So the board needs to ensure that it has adequate information, that there are control system allowing the board to know about what's going on with the company. So here are some examples of what kind of, so in terms of, so what gets board members in trouble if they don't know about something. Daniels and Anderson. So the problem always arises when the world changes, the company's business becomes different in a way that the current board isn't familiar with. And that's not the problem. That's absolutely fine. But when that happens, the board needs to familiarize themselves, and that is find people that control that business. So you need to, so Daniels and Anderson was a case which had to do with foreign exchange trading, new at the time. And the directors didn't know enough about that, but that wasn't the issue. They also had no one who knew something about it to control that aspect of the business. Healy is an example, an Australian example, and so we don't quite know if that would be decided exactly in the same way here, but it's worth looking at. It had to do with a $4 billion short-term liability on a balance sheet, which the directors knew existed, but didn't know that it wasn't on the accounts. And it was held, they were liable because there was not a mere technical oversight. And they had to apply their minds to the financial statement. I know 4 billion is quite a lot, and it was also short term, so that makes it even more significant. Let me bring this back here. Yeah. Okay, Bearings is another example. So the takeaway is you cannot allow yourself to be dominated by one individual, and have to ensure that there's and you're judged by the quality of your internal control systems. So here's what the Corporate Governance Code says: establish procedures to manage risk, oversee the internal control frameworks, and determine the nature and the extent of the principal risk the company is willing to take in order to achieve its long-term strategies. So the board has moved from being something that acts on suspicion to something that proactively identifies and manages risks. So that's a very big shift in terms of what you should be doing, because that involves working out how do we find risk, what is the risk, and I've given you the guidance of the Financial Reporting Council on how to manage risk and internal controls, and we discussed how you would do that for the LSE. So this was the shift of the role of the board. Then there's the Company Directors Disqualification Act, which shows us that there's a public interest in the quality of managing directors. So a director gets into trouble if a company goes into insolvency liquidation and it emerges that they were unfit to be concerned with the management of a company. And here are some examples of this. What is worth noting, so this usually covers smaller companies, but also very large ones, but it also covers smaller companies, and there's more of those. So what gets you in trouble is not accounting properly, not knowing enough about the risk of the company, and being negligent about keeping yourself informed of the numbers underlying your business. So ordinary commercial misjudgment is fine, but lack of probity and also total incompetence in relation. So Seven Oaks stationers, no proper accounts kept, no annual accounts prepared or audited, no returns filled in, and also then being lacking probity by incurring debt when you should have known that you're in financial difficulty and only paying creditors who really press you to pay. So the idea is very much one of being informed about your risks, and then if you judge your response and that is sort of for that, the court is very unlikely to second guess you. Now, there is another approach, or a more, so the courts involve themselves in sort of, they sink their teeth into, did you know enough? What they don't do as much is, or hardly at all, is review, were you responding in a way that is that they agreed with. So here's the example of the German Joint Stock Companies Act. Defines the care of a diligent and conscientious manager. Standard is objective, specifically refers to the capital maintenance rules, and there are sort of compliance with the law, cultivating a collegial atmosphere, also familiarity with accounting and financial planning. And this decision-making is shared, of course, between the management and the supervisory board. So on the face of it, not very different. Perhaps diligent and conscientious looks a bit like a higher standard here. So there's a sort of, these are stronger words than skill and care. And we find that the courts tend to be more involved. So if you look at Garmin-Beck, which was a case where the supervisory board had to decide whether or not to enforce a claim against the managing director. And that is, you could say it's an entrepreneurial decision, which is what the Court of Appeal found, because you need to, so of course there's a legal component to it, but there are many other factors. So for example, do you have enough evidence? What's the cost of the litigation? Is the claim likely to be enforced? Is it likely to be enforceable in the sense of, does the defendant have enough money, or have they all the money they have. If they've hidden it, can we get to it? So there's a sort of Court of Appeal says this is an entrepreneurial decision. The federal court says, no, it's not, because the supervisory role, there's no discretion for the supervisory board in the supervisory role. And so that's a lot more involved than anything we've seen in the UK. So the federal court, highest court, says a well-founded claim has to be enforced unless the circumstances are exceptional. And here's another example following the financial crisis, where the court held, the instruments that this bank bought were ranked by a credit rating agency, and they should have known that the credit rating agency was biased. This all was too good to be true. And so the securities were associated with risk on unknown debtors, and they should have known that the risk of default of all of them was identical. So the risk wasn't sufficiently spread. So there we look again at this sort of the broad question. The UK has a duty of skill and care with a focus on internal control. No review of the judgment of the carried out in the response to the risk assessment. German law has more of a review of the decision. And then, of course, there's an article on your reading list about criminal sanctions. Should there maybe even be criminal sanctions? And you need to work out what's best, what you think works best. A sort of an approach where you look at control systems, are they adequate, and then say judgment is not for the court to review, or control system plus some form of review of judgment, or going all the way to saying at some point there's a criminal sanction attached to negligent behavior, and then of course you need to work out how do you define the negligence that justifies criminal intervention.